Sean Noble of American Encore is with us in studio in the mothership just outside of Washington, D.C. Sean, how you doing, sir?
Doing well. Glad to be here.
Yeah, thanks very much for coming in. A big day in the Supreme Court yesterday, and of course, look, some folks have lost their minds, I think, over the Hobby Lobby decision. Let's start there. How big a decision is it? And if you were a progressive, Sean, would you be losing your mind over this decision?
Well, progressives have to lose their mind over 5-4 decisions that go against them just by nature of their DNA. I mean, they are hardwired to claim that the world is coming to an end and everything that even goes iota against them. The thing that's interesting about this case is that it's actually not that sweeping. This has nothing to do with limiting the ability for women to have contraception. This is merely the court saying there's a couple instances in which this does actually impose on the religious freedom of individuals who run companies. And guess what? I mean, I think the most important component of this case is a side component, and that is, if you remember how much fun the left made of Mitt Romney when he talked about how corporations are people. Well, guess what? The Supreme Court just said corporations are people. I mean, that was a central component of the argument against Hobby Lobby, was the government saying, no, these people can't be considered persons because they're a for-profit corporation. Well, the Supreme Court said, nope, that's not the case. They are, in fact, people, and so they do have religious freedom or religious liberty. I think that's a big deal.
Now, Sean, well, listen, okay, so again, people who don't want to try to understand this decision, the actor Dax Shepard from Parenthood was tweeting about this, and he said, well, this is great. I look forward to Olive Garden. I think Home Depot being able to marry Olive Garden since we've, recognized corporations as persons, as if this is some sort of new concept. And this is what I find not just sad, but I kind of find it scary because this isn't some brand new concept. It's not as if the Supreme Court suddenly decided, well, you know what, corporations, we're going to consider them people, Sean. And this, I think, completely mischaracterizes and misrepresents the ruling to say that this is going to now lead to corporations marrying one another.
Absolutely. I mean, it is just a sense of how uninformed some on the left are. Now, that's not to say that some of us on the right aren't uninformed in some things as well. But when the progressives that kind of put themselves out there as kind of sending the messages of what this should be about, get it so wrong, it just makes you wonder, what is it that we need to do as an American people to better understand how the process works, how our government works, how the checks and balances of government work. I mean, Sandra Fluke has a law degree, and she got this fundamentally wrong in the tweets that she was sending out yesterday. And, those are the kinds of things that we have to continue to educate people on and have the conversation. And it can be very painful because some of the stuff that we get hurled at us is you can't even respond to because it's so asinine.
Well, it is. I mean, again, take this back to what the case was about. I know people are going to want to make this about, birth control and, women's access to birth control. And darn it, the Supreme Court just, took away women's access to birth control, which is not the case. Again, this was specifically over 4 types of birth control that the individuals who own Hobby Lobby did not want to cover. Megan McArdle, writing in The Atlantic, says the question in this case was whether this was a legitimate claim under the 1993 Religious Freedom Restoration Act. Did the mandate substantially burden these companies' ability to practice their religion, and did the government have an alternative way to accomplish its goal of providing contraceptive access? For that matter, could companies even have religious freedom rights? Lost in all of this is that religious nonprofits had been exempted. The Obama administration said, okay, we'll figure out a way to provide the birth control in the absence of these companies doing so. But again, all of that I think is lost here, Sean, in favor of this rhetoric that I think is simply designed in large part to try to motivate progressives to get out and vote this November.
Oh, no question that they're using this as a get out the vote mechanism. They don't really care about the merits of the case. I mean, they may care about it, but they're not focused on the merits of the case at all. I mean, this was an instance in which, it's what's so frustrating to me is how much they trashed what the court did when RFRA, the Religious Freedom Restoration Act, was sponsored in the House in 1993 by Chuck Schumer, was sponsored in the Senate by Ted Kennedy, passed the House unanimously, passed the Senate in 97-3. The three no votes were Bobby Byrd, Jesse Helms, and Mitchell from Tennessee, or I don't remember his last name, but it was a senator from Tennessee, 2 Democrats, a Republican, and signed by President Clinton. And somehow this was a terrible thing now in hindsight. I mean, it is convenience. You know, they basically say we're only going to follow those laws that we think are convenient for advancing our policies, even when they are the very people who passed and signed the law. Yeah.
All right, so let's talk about the second big decision yesterday by the court, the decision based on this Illinois law that had said that home health workers, because they are indirectly paid by the state, therefore are state employees, even though they contract with individuals. This ruling that these folks are not state employees, that they don't have to provide a portion of their paycheck to the SEIU. What kind of ramifications could this have, Sean? Because it seems like, again, I'm reading a lot of commentary that Justice Alito, in this majority opinion, sort of gave the go-ahead to challenge the underlying premise of these public employee unions being able to force employees to contribute to them, generally speaking.
Yeah, this is a very, very important case. This is a case that's going to have ramifications for years to come for a variety of reasons. First, let's go back to the basics. I mean, just the contours of this case are amazing. So there was a woman named Pamela Harris who cared for her disabled child at home and received Medicaid payments to do that. One day she notices that SEIU is deducting a fee, a union fee, from her Medicaid payment. And she's like, well, that's not right. I'm not a member of SEIU. I'm not a union member. I'm just caring for my child at home in this home health care situation, being covered by Medicaid. So she sued. And so this was the actual fact that the courts were faced with, which is an amazing thing. It's the overreach by the unions and by Governor Blagojevich in Illinois at the time, and then Governor Quinn in Illinois that's carried on. This will have ramifications because obviously there's about $20 million a year that goes into the unions as a result of these home health care workers that are now going to be taken out of their coffers. That's going to leave a mark, so to speak. But the ramifications are going to start to go across the nation, because not that this case automatically takes all home health care workers in every state out of the mix, but the Supreme Court now has laid the groundwork for the challenges for all of those folks. And as you pointed out, the very premise of public union employees being forced to pay dues is undermined completely, and I think we'll see challenges of that. For me, the precursor of this was the best synopsis of this case, of this issue, was actually written by Thomas Jefferson a couple hundred years ago. He said, to compel a man to furnish funds for the propagation of ideas he disbelieves and abhors is sinful and tyrannical. And I think that's exactly what these forced union dues are all about. It's forcing people to give you money so that you can go propagate ideas that you may not agree with, and do so. So basically it's taking your money, saying, I don't care what you think, I'm going to use your money, essentially your speech, and speak the way I want it to. I want to speak.
In that sense, Sean, even though this didn't undo, it was a narrow decision. It seems like it was an important one, could set the groundwork, much like Heller, in the technical sense, was a narrow decision. It didn't, take on D.C.'s right to carry laws or anything like that, but it was a hugely important decision that set the stage for the McDonald case a couple of years later. One of the troubling things I think about this is, again, these were 5-4 decisions. You had some pretty strong dissenting language in these cases that suggests that there's a strong undercurrent on the court right now that doesn't really think that individuals running their own businesses have any right to bring their religious beliefs into those business relationships. That's simply not appropriate, and that folks should actually be compelled to provide funds to unions that they don't want to belong to.
Yeah, I was a little bit taken aback by the shrill nature of which the dissent was written by Ginsburg. I mean,
in the Hobby Lobby case.
In the Hobby Lobby case, and just I mean, there is a very, very activist court waiting in the wings if things do not go the way that we would hope that they would go, and we have conservative justices, or at least moderate justices, remaining in the majority of the court. A case like the cases like these are the ones in which you realize, you can have all the disagreements you want in the primary season if, on the Republican side, but when it comes to, whether or not you're going to, support the nominee or just sit home, we're one vote away on the Supreme Court of a whole lot of things going a very different direction. And so I think that just
absolutely
just heightens the importance of conservatives and freedom-loving people to be engaged in this process and right to the end, not to just, play for your guy, and if he loses in a primary or in the nomination process, go, hang it up. You got to stay involved in the process.